April 28, 2004. Supreme Court Clerks Roundtable was held at the Robert H. Jackson Center, featuring clerks from the time of Brown v. Board decision. The Robert Jackson Center was privileged to have 4 of the law clerks who worked in private and in confidence for the 4 principal justices who participated in deciding the Brown case. The law clerks included Barrett Prettyman, Jr., Justice Jackson's clerk, John Fassett, Justice Reed's clerk, Frank Sander, Justice Frankfurter's clerk, and Earl Pollack, Justice Warren's clerk. They came to the Jackson Center to recall the Supreme Court's decision-making process in the famous Brown v. Board of Education case. 50 years since the Brown decision, criticism continues. The decision was not forceful enough. There was not enough progress made to end segregation in public schools. However, despite its flaws, the Brown case is still regarded as the cornerstone in dealing with racial equality.
Were you there for the oral arguments, and what do you recall of that forensic moment in this piece of history? Earl?
I was in the courtroom. The Chief Justice expected any clerk who had been assigned to work on a particular case to be present during the argument. And although I don't recall the dramatic moments of the argument as much as I would like, I do recall very clearly the argument that Thurgood Marshall made. It was very effective. It was very emotional, not by any means confined to arguments about stare decisis or other technical legal issues, but emphasizing the extent to which white and black children who played together, who spent time together, were then suddenly separated along 2 different tracks once they began their public school education. It was a very effective argument. I don't recall Davis's argument.
That's John W.
John
Davis.
W. Davis, who then regarded as really the dean of the American bar, probably a man who had argued more Supreme Court cases at that time than anybody else in the country. It was an eloquent argument, but it was, of course, limited by the fact that his position had to rely to a much greater extent than Marshall's on technical legal arguments as to why the court should defer to the doctrine of stare decisis and not undertake to overrule Plessy versus Ferguson after all those years.
Right. Derek?
Yes, I heard both those arguments too. I don't think I heard all of the arguments that were given because it went over a couple of days, but I do remember those well, and I would add to what Earl just said about John W. Davis, who incidentally had been a presidential candidate at one point. He relied heavily on states' rights in addition to stare decisis, and his theme was, you have even said in your opinion, Supreme Court, that education is a matter for the states. Educating children is not some big federal thing. It's states' rights. It's what the state does. And now, all of a sudden, you're trying to take away from the states this right to decide where children go to school. Why not leave the matter with the states, which I thought was really very clever, because that appealed to something which a number of the judges actually did believe in. I must say that in my own mind, I thought the die was cast in these cases when they agreed to hear the cases. It seemed inconceivable to me that as late as 1954, that a majority of this Supreme Court would say that it is still valid under the law to separate children solely on the basis of race when they go to school. So while arguments are always important, and while these were very good arguments, I'm not sure they dramatically affected in any way the result in the cases.
I'd like to agree just briefly with Barrett on that. It frequently is thought that it was the compelling argument of Thurgood Marshall that caused the court to decide the case as it did. I think that is quite an overstatement. I agree with Barrett that the argument did not have that substantial effect on changing anybody's mind.
Not even toward the ultimate unanimity of the court?
I doubt that. I doubt that. I think that many Supreme Court arguments are really more designed to avoid losing than to achieve winning, and
Having lost a few, I would agree.
yes, and I doubt very much whether it had that substantial effect on the ultimate outcome.
I agree entirely. I don't think the oral arguments, which spanned the 3 days of December 7th, 8th, and 9th of that term, while it was interesting and it was quite a public drama, I don't think it affected the vote one iota. The interesting things that had happened before then were that on November 1st, they filed all these briefs with the answers to the 5 questions from the June 8th order of the end of the prior term. And on November 1st, right after that, Justice Frankfurter circulated the long memorandum that Alex Bickle had written on the history of the 14th Amendment. Those things were what the justices had studied, and though they asked some questions of some of the arguers with respect to that, nobody changed their mind as a result of it. Another thing that happened in between here that's very interesting that is seldom mentioned. On December 1st, we remember it because it was quite a big day in the life of we young law clerks. President Eisenhower and Mrs. Eisenhower reinstated the procedure of a White House reception for the judiciary, inviting the justices, and of all things, they sent engraved invitations to each of us, I guess, and my wife, and we had to rent white ties and tails and went off and got to shake the hands of the president and introduced to Mamie and talk with him, and Herb Brownell was there, the Attorney General, and it was quite an occasion, but the timing is very interesting. December 1st, the argument was scheduled to start on December 7th, and there are some stories that go on about the Chief Justice having been taken aside and having had some words said to him during that. It didn't affect the outcome, obviously. But as to the oral arguments themselves, like Barrett, I was very busy working on other cases and doing a draft of another opinion for Justice Reed, so I couldn't go in there and sit there all day, and the justice hadn't asked me to. So I went in and out, but there were certain of them I wanted to hear. I heard part of Thurgood Marshall and part of Spotswood Robinson. We had a special little place where the clerks and the secretaries could go in and see and go in and out. Anybody else, you had to come in through the main way in the court, and it was a real problem to get in for something in demand as that. I particularly wanted to hear John W. Davis, and I did, because as I concluded law school at Yale, one of the firms I interviewed with, they invited me down to New York, and when they heard I'd been recommended to go to Justice Reed, the interviewers ushered me into John W. Davis's office, and I didn't realize what was going on at the time, but he explained to me how he knew Justice Reed and what a fine gentleman he was and whatnot, and hoped I would get it, and so Larry turned up. He was way ahead of me on that one.
You think he was doing a little lobbying?
It happens, you know.
Now, the court's procedure, and it's an important reminder that the court is not only doing Brown versus Board of Education during this or any term. Its procedure after hearing oral argument is for the justices alone to meet in conference to discuss and vote and then assign opinion writing responsibilities. And so after that oral argument and those oral arguments over those 3 days, the court has a conference and the justices emerge, and something is in the process of having been decided or being done with the school segregation cases. Frank, did you have any understanding of the conference and its result?
No, it's one of these questions that I know the answer to now, but didn't then. So I don't want to recreate history.
Okay.
I don't think any of the clerks knew the answer.
Yeah, I mean, I guess I just want to say we're getting a little false picture of the involvement of the law clerks. the three gentlemen that are sharing the platform with me as law clerks were exceptions. The general rule at the Supreme Court was that law clerks would have no role in this decision, because even then the fear of leakage would be so serious. So there were some violations of that by some justices, including my own, but not that there was a report of what happened at the conference, which often justices discussed with their law clerks afterwards, but not in this case.
Well, was it true for the other three of you that there was an information blackout about these cases coming out of that conference? Or did you come to understand where the court was heading?
It was common knowledge that this was very close to the vest, and only the people directly involved should have anything to do with it. I didn't know Barrett was directly involved. We never discussed it at the time. I didn't know who was working on it for the Chief Justice, but Justice Reed had fingered me to be the one working with him, and I'd been working with him since the summer on what he was thinking about doing. But the secrecy was very strict, and most of the law clerks had no idea what was going on. On the December 12th conference, when they came back, I assume we always had the conferences on Saturday afternoons in those days. When they came back, he'd open his docket book and tell us what had occurred, but nothing with respect to the segregation cases. They had no vote. They decided at that occasion that they would not have a vote. They'd continue to talk about it until they got to a stage where there could be a vote. And I think one reason for that is that, as you mentioned, Chief Justice Warren was an interim appointment. He had not yet been confirmed by the Senate, and so he wasn't confirmed by the Senate until March 1st. So their first vote, I'm firmly convinced, he said in his memoirs that it happened in February, but I'm convinced it didn't happen until the first week of March.
And I think Warren was the politician, recognized that it was a bad thing to get people to commit themselves.
Sure. I agree with that.
Before they saw anything on paper.
Yeah.
Exactly.
You know, it has to be understood how unusual it was not to take a vote, because it was very customary after an argument that the justices convene and take at least an initial vote. This was not done in that case, I think for the very reason that Frank has pointed out. The Chief Justice, I think, recognized, and I'm sure other justices did too, that it would be inadvisable to take a vote which might freeze certain justices into position before further work and discussion could take place in order to arrive, one hoped, at unanimity. Not only unanimity, but unanimity without dissents or concurrences.
Did you observe your boss, the Chief Justice, doing this informal working on his colleagues toward those objectives?
Yes, yes. I was not present at those sessions.
You mean in one-on-one?
One-on-one.
One-on-one. I wasn't present at those, but I was aware of the fact that he was very patiently attempting to discuss the matter on an individual basis with each other justice, whether a conference in chambers or lunch or taking a walk around the Supreme Court building. I knew that this was going on.
Barrett, from your perspective, what was happening, what was Jackson up to, and what was happening in Jackson's thinking in this post-conference period?
He did not tell me anything about votes after that conference. I did get the impression that he thought that a majority clearly was going to strike down segregation. But don't forget, it was early in the next month when he first gave me this draft that he had gone through for many months of what he thought was going to be a concurring opinion. And it was right after that when I wrote a memo back. And I've said before that, to show you how naive I was, I wrote that in my office on my typewriter, did not give it to Elsie Douglas, the secretary for typing, as I normally did, gave it to him myself, and it never occurred to me that anybody else in the entire world would ever see that memo, which of course has now been published in books and everything else. But I was quite critical of it. I thought it was very defensive, and I thought it said some things which would give grounds to particularly those in the South for combating any decision striking down segregation. And it was soon after that, I hope not because of that, but it was soon after that that he had a heart attack. And then he was in the hospital when, I'm jumping ahead now a little, but he was in the hospital when the Chief Justice brought his first draft of Brown around.
So Jackson's drafting a concurrence before he's ever seen a proposed approach by Warren.
And before they'd ever taken a final formal vote.
Okay. What was Frankfurter doing during this post-argument phase?
I now know that he had some written thoughts too, some kind of a concurring opinion. There were a lot of discussions with Justice Jackson about possibly writing a joint concurrence. We had nothing to do with that in our office. I think the first formal involvement we had was much later, when an opinion had been drawn up by the Chief Justice that was being taken around, and Frankfurter, I think in violation of the agreement, one afternoon came in and showed it to the two of us law clerks and said, do you have any quick reaction to this? And retrieved it very quickly. That was the limit of it.
Okay. What was Reed up to? The previous summer, he had been thinking, researching, assigning your predecessor and you to gather information in anticipation of being a dissenter.
Yes. He, after he arrived back Labor Day, we had these extended discussions about it, and he assigned me a number of additional footnotes to prepare on various subjects, such as what has been the position of the United Nations on its Declaration of Rights with respect to segregation over the years, what has been the position of the Catholic Church was one of them. One of them had to do with the role of the NAACP. Had it ever taken the position until very recently that segregation was...
Jack, didn't you say that one of them had to do with the crime statistics?
He asked me to get... That one came in one of the letters. That was before he came back. He wanted crime statistics compared from various cities, and he identified the cities, one in the north and one in the south, on cities where things were segregated and non-segregated. And I had no idea how to get these things, but Helen Gaylord, his longtime secretary, bailed me out a little bit, and she got in touch with the FBI and sent me up there, and they tried to help me. What I got was not too conclusive, but I had all of these footnotes. And then when the Alex Pickles memo came around and the briefs came around in the 1st of November, he asked me to write 3 more footnotes. One about what the role of the states was, what they thought about segregation in schools when they ratified the 14th Amendment. One, what the Congress that proposed it had in mind about it. He also asked me to do one about segregation in the armed forces. Show the fact that in an area where the executive branch of the government had control of the situation, nothing was done until an executive order was issued by Harry Truman fairly recently.
Jack, let me stay with you. In early 1954, Reed shows you some drafting he had done of a dissenting position. As far as I'm aware, that's the only justice writing of a proposed dissent in the Brown cases.
What happened, you see, was that we went up until the time of the oral arguments, and after that he asked me for no other things. I had many conversations with him about what he was going to do, and I argued with him. I said, you got to look at this from the point of view of the role of our country in the world. And he said to me, boy, have I been hearing a lot about that. He had been having lunch with Burton and Minton, and they've been talking about it. And they were both committed to overruling Plessy. And the Chief Justice, I know, had been meeting with him. But none of these meetings involved any law clerks. The one supposed occurrence of Warren and Reed and a law clerk that appears in Dick Kluger's book, Simple Justice, I'm convinced is erroneous. And the fellow who was identified there as doing it has denied that he said so. So it makes it...
So what about Reed's writing? His draft of a proposed dissent?
So what happened was that we'd done nothing on a dissent after the oral arguments until the court went into recess on February 9th of '54. And out of a blue sky, he called me in there, and he said, "Jack, take a look at this and tell me what you think." With sort of a twinkle in his eye. Stanley Reed could be a very pleasant man. We'd been having all of these extended discussions. And so I took it out. And as we law clerks, we each had our own big Royal typewriter and typed all our own stuff in those days. And so I made a triple-spaced copy of what he'd written, and then I went through and made comments on each of the things, and I'm sure each of you did on occasions with things. And I went back in and talked to him about it. And his reaction was sort of a ambivalent sort of thing. I'm sure.
What was the main pitch of the dissent?
The main pitch was that the Equal Protection Clause issue had been settled. History had settled, and Plessy and the history of the 14th Amendment. So the only question open was whether, under the Due Process Clause, it should be overruled. And he went on at great length, but never came to a conclusion in the thing. And it was yellow pages, and I'm convinced he'd written it the former summer while he'd been off at Oyster Bay and was thinking about it, and that he was just sort of teasing me at that stage. But I took it back, and I kept this whole file of these footnotes and whatnot I had.
But at the time that you went back to him, is it your view that he had changed his mind?
It's my view that he had already told the Chief Justice that he would join an opinion if it was an opinion that he could accept. And I think that's sort of confirmed by Frankfurter's letter to him of May 19th, right after it came down. Frankfurter congratulated him on having joined it, and
I thought that was pretty late.
Well, I don't think Reed made that clear to the Chief Justice until almost the end of April, because...
Yes, tell us why, because this unanimity is part of the accomplishment here. So it's important to try and date it as best we can.
Well, what happened was that in the week of April 26, Chief Justice Warren took a pen to hand and a yellow tablet and scratched out what he later told me he thought was an outline of a opinion, and it's available now on the internet, I think. It was he had it typed up into about 3 typed pages, and on April 29, which was a Thursday, he called me into his office. He gave me this document, which was headed memorandum, and he called it an outline. Said that he wanted me to revise and expand it into a full opinion. He said he wanted it to be short, he wanted it to be readable, he wanted it to be non-legalistic, he wanted it to be something that could be understood by the layman, and he said something that even could be published on the front page of a newspaper. And he also said speed was of the essence. Of course, he told me that it was unanimous. I mean, I understood from what he was telling me is that he had just achieved the agreement for unanimity.
In late April.
Yes, in late April. And he also cautioned me about the need for tight security on it, and that there was not even to be any discussion with anybody outside of the Chief Justice's chambers.
Earl, may I ask you a question?
Yeah.
I have seen just recently the draft. Nina Totenberg showed it to me when she had her program. And from a quick look at it, it looked more than a 3-pager. It looked like pretty much the final opinion, yet it was in his handwriting.
No, it's the longhand is something like 9 pages in longhand, but it types up to about 3 pages. And he clearly, in this memorandum, established the framework of the opinion, and also The memorandum has at least two of the most stirring sentences that wound up in the final version, including the hearts and minds, and we cannot turn the clock back. But probably close to half of that 3 pages never wound up in the final opinion.
But my question is, how did it get from the 3-page handwritten draft to the 9-page handwritten draft? Was that, in other words, the 9 pages
No,
was after
it went
you were...
from 9 pages longhand with maybe a few sentences on each page to 3 pages typed up. And what he gave me were the 3
And
pages.
at that point, it goes to you as an assignment to
That's right. That's right.
flesh it out.
That's right.
Okay.
Do you want me to continue on that?
This is where the action is.
All right.
What did you do next?
This was all about.
Well, with the hubris of youth,
We had lots of it those days.
I started work on it the very next day and worked about 24 straight hours. And that brought me into the weekend. And this was mostly in longhand at home because I did not have a typewriter at home. Brought my longhand revision into the office Monday morning, had it typed, and I presented it to the Chief Justice with a cover memo, which is also now on the internet someplace, saying that I've tried to carry out your instructions, and I then said that there was, as part of that, this draft included all 5 cases that I said I strongly recommended that the District of Columbia case be stripped out because you could not rely on the Equal Protection Clause.
That applies only to state governments.
That's right.
Right.
And also, his opinion, or his draft, had made references to both due process and equal protection, and in fact even also referred to constitutional privileges. I felt very strongly that the state case should be tightly limited to the Equal Protection Clause. Among other reasons, if we got into due process, then we have to confront the question of, does the Supreme Court really want to rely on substantive due process, which involves all kind of issues for the courts? I thought it should be limited to the Equal Protection Clause, and my revision so provided. But he agreed that that's the way it should be restructured, and that there should be a short opinion on the D.C. case, which was assigned to the other 2 clerks in my office. And he accepted the entire revision that I gave him. What happened the next few days, there were a couple of stylistic changes in the May 3 revision. There was some stylistic changes on the 5th, I think, and on the 7th. Didn't amount to much. Also, footnotes were added that week. And then on Friday, on Friday of that week, that was May 7th, the chief decided that this opinion was now ready to be circulated to the other justices.
Right.
And he prepared a cover memo, which in large measure repeated what he had told me on April 29 about his concept of the opinion. The cover memo said that here are these drafts for, he said, for discussion. And he said, as you'll see, the opinion of the drafts are short, non-legalistic, and he says that they should also, above all, be non-accusatory, as he was already thinking in terms of acceptability by the South. That Saturday, he took copies and delivered one to each of the justices who was present in the court at the court at that time. There were two justices who were not present, Minton and Black, and another clerk and I.
Well, and Jackson, who was in the
Oh,
hospital.
that's right, and he delivered it personally to Jackson. Quite right, quite right. We delivered Minton's copy to him at his apartment, which was, I think, located just across the street from the Supreme Court, as I recall. And then we went out to Alexandria and delivered Black's copy to him while he was in his tennis clothes on the tennis court. And he stopped the game and
Started
thanked
reading.
us. Yeah, I don't think he read it right then and there.
Now,
But that was May 8th.
Tennis
Right.
first.
Saturday,
Tennis
May
first.
8th. Now, for all the security strictures, it's probably shortly thereafter that Frankfurter quickly shares a peek with you and your co-clerk, Jim Vorenberg.
I think so. I can't place the date, but that would fit in with this picture. Yeah.
Right. What was Frankfurter's reaction to the long-awaited draft by Chief Justice
Well,
Warren?
my best recollection is that he was very pleased because he thought it should be unanimous. I think he'd come around to that. He had some serious concerns about the role of the judiciary that we've talked about and judicial restraint that he's a great proponent of. And so I think he had these concerns, but he saw this movement towards unanimity and clearly felt that was the most important thing. So he was ready to jump on the bandwagon.
Now, Barrett, as we've said, Jackson was in the hospital, and Earl has mentioned that Chief Justice Warren personally delivered the draft to Jackson. Pick it up there and tell us what happened.
Well, Frank, this is one of those things I actually remember.
At least you say so.
Yeah. I do remember quite well. I happened to be with Jackson in his hospital room when Earl Warren came by, and he made it clear very quickly what he was there for. I excused myself and went down the hall. I waited until a nurse came down and said that the Chief Justice had left. I went back. Jackson by then had read the opinion, didn't say anything about it, handed me a copy and said, go read it. I went down the hall again, I read it, came back, and we talked about it, and it was very obvious that I guess the best word I can use is that he was relieved. He was very relieved that something had been presented that he could go along with. Even though, I have to emphasize, there were parts in it that he differed with Warren on. For example, Warren said that the history of the 14th Amendment was inconclusive about what the framers felt about segregation, segregated schools.
And that, of course, was based on the
Bickle Memo.
Right, right. Jackson thought it was quite clear what they thought, that they had in effect approved segregated schools in the district, for example, but he didn't care. What the framers thought about this now current problem couldn't have bothered him less, and he thought that you had to interpret, as a very practical man, which he was, he thought you had to interpret the Constitution in terms of today's world, and therefore he put that problem to one side. So he had different approaches from what Warren had, but basically he very much liked the idea that it was simple, short, people could understand it, you could easily agree. You tended to read those words and say, yes, yes, when you separate people on the basis of race, you are denigrating the black race. And
Here's a speculative question for you. I've sort of always wondered whether Jackson's heart attack, along with Warren's appointment, was one of the things that made possible a unanimous opinion. Do you think that his physical condition had something to do with his lowering his acceptability point and going along with the opinion, or do you think this would have been the same if he hadn't been ill?
It's a fair question, but I didn't see any signs that he was not robust in mind. I think he was genuinely pleased. Now, he did make some suggestions about changes, one or two of which Warren, one in the Bowling opinion, for example, that Warren accepted, but several of his suggested changes Warren did not want to accept because they related to segregation generally. And as you know, Earl, Warren was absolutely adamant about restricting this opinion to education. And he did not want to intimate that any segregation was going to fall in any other area, even though he knew perfectly well that it would. That was the politician in him, and very wise, I might say. But no, I think that Jackson, he was so pleased that there was no blame, and he just liked it. He thought it was a masterwork, whether it was yours or Warren's. So I don't think his heart attack played a part in that.
Jack, as I said before, when he told the Chief Justice that he's going along, or when there was a clear understanding, it was, of course, all based upon the opinion being something that he could accept. But Justice Reed had done nothing further on a dissent after December. And they had a conference, even though they didn't have the vote until, as I've said, probably first week in March, right after Warren was confirmed. But they had a conference on January 16th having to do, looking forward to the problem of a decree, how it would be implemented. The Chief Justice, I think, my understanding is, had hopes to handle that all in the original opinion. And of course, learned quickly that was not going to get a consensus on that subject. And that's when they decided that they were going to have the further argument the following term. But Reed did nothing on the dissent after that. I'm sure he had, if he had not expressly said so, he had impliedly said so to the other justices that he would go along if it was an opinion that was acceptable. He still had the idea that due process was better than equal protection as the way of doing it, because like Jackson, he thought the history on the Equal Protection Clause on the 14th Amendment was fairly clear. He didn't agree with Alex Pickle's conclusion that it was inconclusive too.
Now, it moves very quickly. Obviously, Warren's starting to write in late April. We're now around May 10th, and it's only 7 more days until the opinion is announced. There's tinkering, suggested language, some is accepted.
Comments came in from the other justices, and there were very, very few, and they were essentially word changes or stylistic. For example, Jackson, and this relates exactly to what Barrett was saying before about the way that Jackson was looking at the issue. Jackson added, with the Chief's agreement, a sentence saying that blacks had progressed tremendously since the time of Plessy and Ferguson, and so that sentence was added. Frankfurter made a change which I regretted. The Chief had, and this was one of the sentences that was in the original memorandum about the effect of segregation on hearts and minds, and the sentence in the May 3rd draft said that this would have, segregation would be perceived as putting a mark of inferiority on the blacks. And that seemed to me very appropriate because it directly refuted the Plessy premise that if blacks saw a badge of inferiority in segregation, it was a matter of their own perception and not reality. Frankfurter, I'm sure he had good reasons for it, asked the the chief agreed to change mark of inferiority to something like generates a feeling of inferiority, and that's the way that came out. Burton, I think, wanted a change from a phrase from some southern states to some states, eliminating that. He even asked for that we identify the case names of the 4 cases more specifically in one of the footnotes. Clark did not have any particular change that he wanted to make, but he expressed concern about the fact that one of the citations in the opinion was to an article by Clark. And,
Not him.
Yeah, not him.
and he was concerned that the reader might get the idea that Tom Clark was the author of that article, and so to accommodate him, and in complete violation of the strictures of the Harvard Blue Book, which we always sought to follow, we put in the initials KB in front of Clark so as to avoid any confusion as to whether Tom Clark was the author.
Do you remember this change in Bowling, the D.C. case, Earl? Jackson had suggested the addition of a sentence, "The equal protection of the laws is a more explicit safeguard of prohibited unfairness than due process of law, and therefore we do not imply that the two are interchangeable phrases." And then Black came along and convinced Warren to put in the word always. So therefore it read, "We do not imply that the two are always interchangeable phrases."
Now,
And Jackson was very upset at that.
Dick Flynn, one of my fellow clerks, was, after I had suggested the removal of the D.C. case from the state cases, was assigned the Bowling and Sharp. So I really was not involved in the revision of that one.
The only reason I know this, I wrote a contemporaneous memo about that situation, and that's what it
My
said.
impression is that Justice Reed accepted the 2 opinions when they brought down on that day without the...
I don't know of any comments that he made, and I know that Douglas sent in a letter saying that he wouldn't change one word.
Hugo
and
Black
I don't
from
recall,
Alabama.
I don't recall any changes requested by Black.
He had signed on long ago.
Right.
He wanted to decide it the whole way in the prior term. Hugo Black was one of the most ardent supporters of overruling Plessy.
So there were very few changes. And then, so,
Well, let's go to May 17th. The next.
well, before you get to May
Okay.
17, you have to get to May 15, which was a conference.
Right, Saturday.
And it was at that conference that all the justices formally signed off, figuratively, on the drafts which had been circulated and revised that week. And it was then decided, we're going to announce this 2 days from now, on Monday. And that is exactly what happened. Again, without any advance announcement of what the intention was, with the result that many of the law clerks for other offices were not even present when the case was delivered because of tight security.
My recollection is that most law clerks were there because their bosses said, well, I think you ought to be in court today, or something like Frankfurter said to us.
Well, Justice Reed came through and said to me, Jack, this is the day you better be in court. And he'd also told Helen, his secretary, but unfortunately my co-clerk had gone off to lunch somewhere,
Yeah.
so he missed it.
Yeah, there were a number of clerks who were off to lunch and who were very angry later on that they had missed the event.
Now, Barrett, for the first time since the end of March, your boss was back that morning.
Yeah, L.C. Douglas, his secretary, told me that he was coming in for the opinion, so I knew it was coming down. But that was, not that long ahead of time, and he did, in fact, arrive, came up through the usual way, basement and the back elevator, and word began to get around the court. So that's several clerks. That's the first indication.
Ellis McKay, who was Clerks clerk, whose office was right next door to Reed, had gone down to the print shop, which is in the lower confines of the Supreme Court building. All their printing is done in this very confidential place down there that morning, or just before noon, and to get an opinion of Justice Clerks that was going to be released that day, or that he was working on. And he saw these huge piles of packages of opinions. They get them ready to give to the press and whatnot as soon as they're handed down, and they had no indication of docket number on them, like always it appears on that. And Ellis came back up and told his co-clerk, who then contacted me, said something's going to happen. so there were rumors traveled fast in there, even though the security was very good. There weren't many people that were forewarned.
And I think the security was remarkable in that I don't think there was any public leak.
No, I don't think so.
It was kept under wraps as far as the court itself is concerned.
How did the lawyers come to be present? Would they just be present every Monday?
Every opinion day at that stage.
Well, now, wait a minute. I wanted to ask you about this because I did not see Thurgood Marshall. I was sitting in a way.
He was in New York. I think that the reports are that he was in New York.
No, but other reports say he was in the courtroom.
He was in the courtroom, and he made much in his oral histories of watching Justice Reed.
A picture was taken of him right outside the courthouse.
Yeah.
So I don't. I wondered if you knew who called him. I mean, sounds like something Frankfurter.
Well, yeah, but Barrett, those were the days, long since gone, when the court would deliver its opinions only on Mondays.
Right.
And so lawyers could show up on Monday thinking, well, maybe this will be the day. Today, the opinions could be handed down almost any day.
Does anyone recall John W. Davis being present?
I don't think he was. No, I don't think he was either.
Okay. Now, the announcement itself can be a fairly mundane event, the announcement of a Supreme Court opinion, the author reading an opinion. I take it this was not a mundane event?
Well, it was in one sense.
Mundane until about 2 or 3 rather unimportant opinions had been read. Then it became non-mundane.
You got to recognize that May 17th was getting very close to the end of the term. At that stage, the terms usually adjourned June 1st, so you only had about 2 more opinion days. So the tenseness was arising because everybody thought something was going to happen, but there'd been, as far as I know, no leak even amongst the law clerks prior to just before noontime when word got out that Justice Jackson had come for that occasion. And
as a matter of fact, the first AP that went out, even after he had begun reading, indicated that the result couldn't be determined from what he was reading. It was only when he came to a key phrase where he inserted a word that was not in the opinion, the word unanimously. He has said in an interview that he heard a reaction from the crowd at that word, and I remember a great intake of breath. I mean, the people present went like that because that's the one thing that they had not expected.
That was dramatic, yes. Yeah. And that's what Thurgood Marshall made much about. He came there, said he sat there and watched Justice Reed because he'd heard this rumor that Justice Reed was writing a dissent. And so he wanted to look him in the eye as it came down, and as it came down, he nodded to Justice Reed, and Reed nodded back and gave him a big smile, and he realized that he had joined it. That's one of the, I think that's a very true statement of what happened, contrary to some of the histories that have come out, quite a few of them that have Justice Reed crying as it came down, and other ones that have him receiving an ultimatum from your boss, from the Chief Justice, just before it came down that, Stanley, you've got to join this now, citing a law clerk being with Reed when he had this conference, when we know that the Chief Justice would not have had somebody's law clerk, even somebody working on it at that stage. So there have been some myths, and some of them, once they get issued, they get propagated.
The decision, of course, unanimously held that separate but equal has no place in education, and then deferred the question of how segregation was to be remedied. Were there misgivings among your bosses or among you as clerks about this approach to the remedy question?
Well, I think in our chamber, we then had some discussion about this whole question about deferring the enforcement, and Frankfurter, I think, was one of the leaders for that move to put the defer the enforcement question, and then came up with his phrase, "with all deliberate speed," that finally appeared in the Brown 2.
Mm-hmm.
So
1 year later.
1 year later, yeah.
Right. Was that necessary to accomplish unanimity?
Absolutely, absolutely. In fact, the idea that the court could have said, we now order admission of the plaintiffs and the destruction of racial segregation forthwith, I think is essentially, well, to put it mildly, unrealistic.
But it's what the plaintiffs asked for.
That's what the plaintiffs asked for, but plaintiffs frequently will, let's say in damage cases, may ask for billions but not expect that they're going to get it. But no, there are two reasons why that really would not have worked. First of all, it would have absolutely inflamed the South, would have lengthened the time of resistance, made it much longer than the long time that it took. And second, there would never have been unanimity. There would never have been unanimity. I think at most there probably would have been what I think would have been a disaster, maybe a 5-4 or 6-3 decision, maybe spanning 100 or 150 pages of concurrences and dissents. There would have been no authoritative voice of the Supreme Court on this issue. And it's very easy for some authors today to look back and say, well, you know, it would have been better if we'd just done it that way. But I just don't think it's realistic. Black subsequently told his law clerk that he thinks the court should have ordered desegregation forthwith. And Warren has expressed some sympathy with that, but I think that is speculation after the fact. And the only realistic way of achieving unanimity and avoiding dissents and concurrences was to follow the two-step procedure that the court followed.
Let's conclude by taking the 50-year perspective that we have on this as an accomplishment of the Supreme Court, but as a social issue that continues to bedevil the country and definitely remains on the list of unfinished projects. What is the accomplishment and the significance of Brown versus Board of Education from your perspective as an insider and as a proxy for one of the creators of as much as the court got done?
I think this is one that's really difficult to cast yourself back 50 years, because I think many people thought at the time the problem is solved. Marshall is said to have said that in 5 years from now there won't be any more segregation. Well, that obviously has not happened. Mm-hmm. I think I'm intrigued by the fact that some Afro-American authors recently have criticized the court and said maybe it would have been better if Plessy and Ferguson had been forcefully affirmed, that is, expecting real equality but still separation. I don't agree with that, but I think it's symptom of the fact that in terms of integration, we haven't gotten very far. I think real meaning of the case is in terms of a statement of national ideals and policy and interpretation of the Constitution. So I think one has to separate what the case means in the broader sense, which I think is terribly important, and one couldn't imagine another result, to its narrow effectuation, which I think has been disappointing. And I'm sort of surprised that these sophisticated scholars have made this argument that perhaps separate but equal, they would have achieved more.
There's been an awful lot of criticism of what has happened in the 50 years that we haven't gone as far as we could. And I'm sympathetic with that, but I think when you get old, you start looking at the big picture a little more. And the big picture of Brown was not just public school desegregation. It was the cornerstone for dealing with racial equality in all areas. And as a former corporate executive, for example, what it meant in the employment patterns of companies. I had the first 2 black directors on my board of directors after I became a head of an electric company. And in politics, you see black people at the top level, and in the legislatures. You see it in every area of our society. That all goes back to Brown versus Board of Education. Now, the public schools have problems, there's no question about it, but most of them don't have any basis in the Brown decision. And like Frank, I think it would be a terrible decision if they'd reaffirmed Plessy. But you know, we've got problems with housing and with economics and with parental control and whatnot. But that does not negative the very many positive things that have come out of it.
That was exactly the point that I was going to make, differing with you just a little bit, Frank, and that is, I think you have to segregate, if you will, education in the rest of the world. In education, the progress has been disappointing. It has been dramatic in some areas. In the District of Columbia, they did away with segregated schools at that time right away, and in many other parts of the country. But overall, we are seeing more and more segregated schools for whatever reason. But Brown was the beginning of dramatic changes. At the time Brown came down, you had separate drinking fountains for blacks and whites in the district. African Americans could not go into Constitution Hall. You had these tremendous burdens that began to be lifted with that decision, so that black politicians began taking over in cities and legislatures, all kinds of dramatic things that have happened. And we mustn't overlook that. That all really originated with Brown.
Earl?
We sometimes hear comments that the promise of Brown against Board has not been realized. You really have to ask the question, well, what is that promise? Brown against Board did not promise the end of racism, although I think Brown has had a profound effect in reducing racism, as the separate walls have, to a great extent, at least when compelled by state law, have been broken down. Brown did not promise the end of discrimination, which is still undoubtedly a national plague that has to be addressed whenever we can. And Brown did not promise integration. What Brown was all about was a matter of attacking compelled segregation under law. It was not aimed at creating racial balances in our institutions. It was not intended or designed as an end to the horrendous black poverty that continues. It had a very important target, which I think it very successfully addressed, and that is ending the blight of post-slavery segregation compelled by state law. So from my perspective, I think the promise of Brown has been now realized, and that it, I think, deserves its prominence, which we are celebrating here today, as very possibly the most important decision in the history of the Supreme Court.
The Jackson Center is a historical and educational facility dedicated to preserving the legacy of this country lawyer who became Solicitor General, Attorney General, a Justice of the Supreme Court, and served as Chief Prosecutor at the Nuremberg trials of Nazi war criminals following World War II. To learn more about this program, Robert Jackson, the Jackson Center, and upcoming events, the Jackson Center is located at 305 East 4th Street, Jamestown, New York, and found on the web at www.roberthjackson.org or contacted by telephoning 716-483-6646. This program was made possible through research conducted at the Robert Jackson Center and from articles published in the Post-Journal.